thank the panel for inviting me. Yes, sir. Your Honor, distinguished panel members, I would like to thank the panel for inviting me to speak about the Army Special Victims Council program. As the program manager of the Victims Council program, I am excited to implement this program across the Army, thereby ensuring that the victims of sexual assaults will have a voice in our military, judicial, and administrative systems. As the Army TJAG stated to this panel, the crime
All right, we're now moving to presentations about the new Special Victims Councils programs, which originated with a pilot project in the Air Force and now has become service-wide. If we could, I'd like to begin with Colonel McKee.
Yes, ma'am. Your Honor, distinguished panel members, I would like to thank the panel for inviting me. Yes, sir. Your Honor, distinguished panel members, I would like to thank the panel for inviting me to speak about the Army Special Victims Council program. As the program manager of the Victims Council program, I am excited to implement this program across the Army, thereby ensuring that the victims of sexual assaults will have a voice in our military, judicial, and administrative systems. As the Army TJAG stated to this panel, the crime of sexual assault in our ranks is a threat to the Army's ability to maintain readiness. Sexual assault is a crime that degrades esprit de corps, undermines morale, and destroys unit cohesion. I believe our program, in conjunction with the entire process to get after this threat, will be value added to the Army's approach. I would like to inform the distinguished panel about my background. I enlisted in the Army in 1989 and earned both my bachelor and Juris Doctorate from Syracuse University, after which I transferred from the enlisted ranks to the Judge Advocate General Corps in 1994. I have served as both a trial defense attorney and a trial counsel, and I have an Army skill identifier as a military justice expert. I have served at all levels in the Army, from the squad level to the Army staff. I am truly honored to be the first program manager of the SVC program. In this role, I am responsible for the strategic operations and policy updates for the Army Special Victims Council program. I work directly for the Assistant Judge Advocate General for Military Legal and Operations, Office of the Judge Advocate General. I coordinate all aspects of the Special Victim Council program with OTJAG, Legal Assistance Policy Division, OTJAG Criminal Law Division, OTJAG Personal Plans and Training Office, and the Judge Advocate General's Legal Center and School. Finally, as the program manager, I coordinate with the Headquarters Department of the Army G1 on the development and delivery of legal services for victims in conjunction with the Sexual Harassment Assault Response Program, and provide reports on the progress of the Special Victim Council program as mandated by Congress. I am responsible for ensuring that each victim of a sexual assault is provided with a Special Victim Council if requested. I will ensure that we establish and deliver the finest legal representation for special victims. On 3 October 2013, the Army Chief of Staff approved the concept plan for the Army Special Victim Council program. SVCs will be specially trained Army Judge Advocate Legal Assistance Attorneys. The goal was that we would have 45 trained and ready to serve by IOC, initial operating capability. In fact, at IOC, we have 53 trained judge advocates. They are located at 33 installations throughout the Army. Those installations without a resident SVC have an identified installation to turn to for SVC support. The SVC program manager has the ability to allocate assets as needed to ensure every Army special victim has access to a SVC if desired. There are a number of unique factors contributing to the decision to utilize this structure. First, the Army already has a very robust legal assistance program. In a 2011 survey of the Army Legal Assistance Offices, many responded that they were providing services to eligible clients who are victims of crime. Second, the Army legal assistance attorneys routinely see clients whose interests are adverse to the local command. This includes clients with adverse duty evaluations, facing a determination of financial liability due to the equipment loss, and facing a filing determination concerning adverse information. This is unique as other services provided such representation through the trial counsel office. Our legal assistance attorneys are used to representing clients with interests adverse to the command, and our SJAs respect their professionalism in providing quality legal representation in such cases. It was determined that it was unnecessary to create a separate legal structure for SVCs as the legal assistance model was already working efficiently. SVCs are selected by the staff judge advocate based on their military justice experience, sound judgment, and their maturity. They will work under the direct supervision of their chief of legal assistance. As the program manager, I will have technical supervision over all Army Special Victim Counsel. The program manager, along with the local chief of legal assistance, is directly responsible for the adherence of each attorneys to their Army professional responsibility requirements and each SVC's individual state rules of professional responsibility. After selection of quality judge advocates, providing them with specialized training required in this unique position becomes critical to their success. In September 2013, 13 judge advocates and 20 legal assistance supervisors received SVC training. In October 2013, an additional 54 Army judge advocates, 39 active Army, 13 Army National Guard, and 2 U.S. Army Reserve received SVC training. This training included the unique aspects of dealing with special victims, existing programs on and off the installation that support special victims, and specialized training on legal issues involved in sexual assault court-martials. The SVC's primary duty is to zealously represent the best interest of their clients as required by the attorney-client relationship, even if their clients' interests do not align with those of other interested parties, to include the government of the United States. The SVC also helps build and sustain victim resiliency. SVCs will provide the following services to their clients: accompany and advise the victim during interviews, examinations, hearings, and court-martials, represent the victim in court-martial proceedings as permitted by law, refer the victim to trial defense service if there are allegations of collateral misconduct, advocate the victim's interest with government counsel and/or commanders on the disposition options, assist the victim with post-trial submissions to include victim impact statements, advise the victim on collateral civil issues arising from the crime, provide the victim with legal assistance services as needed, and answer any questions that the victim may have about the court-martial process. The SVC will also coordinate with the victim witness liaison and the victim advocates to ensure that the victim is informed of their reporting options, on their rights as a victim, on their eligibility for military and VA benefits, on their right to request an expedient transfer, their ability to obtain a military protective order and/or a civilian protective order, and the nature of the military justice system and victims' rights and duties. While the defense bar has raised some concern that the SVC will become a second prosecutor in the trial, this is clearly not the case. The SVC is representing the victim's interest. In many cases, those interests will coincide with the successful prosecution of the case. However, in others, the interest will not align, and the SVC will advocate for the victim's interest. The Army SVC program achieved initial operating capability on 1 November, and we will be at full operating capability by 1 January 2014. The Army News Service ran an article on 1 November 2013 13, publicizing the Army's SVC program and the services that SVCs will provide to victims of sexual assault. There will also be a story in the Stars and Stripes this week, and there will also be an article in the Army Times next week highlighting this program. As noted previously, at IOC, the Army had 53 active Army SVCs trained at 33 installations. Those installations without a resident FCC have an identified installation to turn to for SVC support. The SVC program manager has the ability to allocate assets as needed to ensure every Army special victim has access to an SVC if desired. In fact, our first attorney made a court appearance on behalf of a victim occurred the day prior to 1 November. At Fort Bragg, a victim requested services from an attorney. The counsel notified the judge, the trial counsel, and the defense counsel. The SVC obtained copies of the client's statement to CID, the charge sheet, the CID investigation, and the pending MRE 412 motion and response. On 31 October, the military judge heard the 412 motion and asked the SVC to appear. At the start of the 412 motion, the SVC moved from the gallery to the podium, and the judge asked the SVC a series of questions about when the SVC began representing the victim, the attorney's state bar membership, and their Judge Advocate General qualifications. The attorney was then sworn before the court. Witnesses were called by both the defense and the government, and both the defense and the government made their arguments. The SVC was then called back to the podium to address the court. The attorney cited a case to the court supporting the client's position. This example demonstrates our program is already working and that our independent trial judiciary has adopted the SVC into our system. As we move towards FOC by 1 January 2014, we are planning both additional online training for our already trained attorneys and an annual course for those who will assume their duties in the future as Special Victims Counsel. In addition to the face-to-face training and online training, we have established a JAG University Presidents, a Legal Assistance Military Suite website for collaboration, and a document library where our attorneys can share forms, briefs, and other documents to provide the best legal services to our clients. Our attorneys have been given a draft of our SVC handbook to guide them in their practice. This handbook includes sample templates and process flowcharts, all of the material to include instructional material at the face-to-face Judge Advocate General Legal Center and School will be provided to the panel. The Special Victims Counsel program is only part of one aspect of the Army's comprehensive program to combat sexual assault, but I believe it will become a cornerstone program for victims of sexual assault because it will provide them with a voice in the process. With this simple action of empowerment, regardless of the outcome in a judicial or administrative process, victims will know that our military justice system supported them and gave them the best opportunity to be heard and the best chance at justice. Thank you all for allowing me the opportunity to address this most distinguished panel on such an important topic.
Thank you, Colonel. Next, we'll hear from Colonel Carol Joyce, who is the officer in charge of the Victims Legal Counsel Organization for the Marine Corps. Colonel
Thank you,
Joyce.
Your Honor. Your Honor and distinguished panel members, as stated, I am Colonel Carol Joyce, and I am the officer in charge of the Marine Corps Victims Legal Counsel Organization. I thank you for this opportunity to appear before you today. I would like to just first share with you a little bit about my background as well before I explain to you the Marine Corps' program. First of all, I've been serving continuously on active duty with the Marine Corps for over 32 years now. I started out as a supply officer and was then later accepted into the Marine Corps' law program in 1986. So I've been serving as a judge advocate since I graduated from Suffolk University Law School in Boston in 1989. I've had the opportunity to hold a lot of military justice billets, and I'd like to highlight just a few of those. As a litigator, I've had the opportunity to be a prosecutor, as a chief trial counsel, and even as a special assistant U.S. attorney representative for the Eastern District of North Carolina. I also had the opportunity to be defense counsel as both the regional defense counsel of the Pacific region, as well as the chief defense counsel of the Marine Corps. I was later selected to be the deputy chief prosecutor for military commissions in dealing with the detainees down in Guantanamo Bay. Recently, I was also an appellate court judge for the Navy Marine Corps Court of Criminal Appeals. As a staff judge advocate and legal advisor, senior legal advisor, I had the opportunity to provide legal advice to senior commanders of 3 major commands, one being a combatant command commanded by a 4-star, that being with U.S. Strategic Command in Offutt Air Force Base in Nebraska. I then also provided legal advice to a 3-star commander for the 2 Marine Expeditionary Force, that being one of 3 major commands in the Marine Corps. And then I had the opportunity to deploy for a year in a combat environment as the senior legal advisor to the commander of Regional Command Southwest in Helmand Province. So I had the opportunity to be out on deployment, observing some of the issues and matters that we're addressing today. And lastly, I had the distinct privilege of also being a commanding officer. As some may know, in the Marine Corps, we get the opportunity to have line officer billets, and I commanded a Marine Wing headquarters squadrons for 2 years in Okinawa, Japan. I believe that my background and experiences have given me the opportunity to see firsthand from different perspectives how sexual assault and other serious crimes impact our ranks, and to appreciate where the gaps are and where we can do better. With that, I'd like to explain to you a little bit about how we got to where we are and how we organized this Victims Legal Counsel organization with the Marine Corps. Just a week ago today, consistent with the Secretary of Defense's memo of 14 August, is when the Marine Corps officially stood up this organization. As the officer in charge, I'm located here at Headquarters Marine Corps, and I'm responsible for the supervision of all the Marine Corps Victims Legal Counsel, as well as to ensure the delivery of the Victims Legal Counsel services throughout the Marine Corps. I work directly for the Staff Judge Advocate to the Commandant of the Marine Corps, Major General Airy. It was he that directed that an operational planning team get together and decide how we were going to do this and how we were going to set up our structure. And we brought together not only trial prosecution experience and defense experience, but we also asked for representatives from the SAPRA program as well as from the Family Advocacy program. And we also had uniformed victim advocates as part of this OPT, and we also had a representative from the Air Force and the Navy, as well as an instructor from the Army School to take part in this planning so we could better decide how we were going to set this program up. I'd like to explain to you how it was for the Marine Corps. Legal assistance attorneys were the ones that were advising or providing counseling to victims of crimes. The problem is that traditional legal assistance in the Marine Corps, the mindset always is that they deal with powers of attorneys, wills, real estate planning, family matters. So what was really happening here is that victims of crime were not really going to the legal assistance officers in the Marine Corps. And they did not have the authority or the ability to actually represent these victims beyond the mere advice and counseling. So we knew we had to do something different. We need to highlight this program and this structure, and that's why we've made it one autonomous, and we've mirrored it with our Defense Services Organization, and we've made it separate and distinct in order for individuals to realize that this is out there and not to be confused with the traditional legal assistance that we've always provided, and that's why it's called Victims Legal Counsel Organization. In our Marine Corps, we have 4 major regions. We have East Coast at Camp Lejeune, West Coast at Camp Pendleton, and overseas Okinawa, Japan, as well as representatives at Quantico, a legal service support section at Quantico for the National Capital Region. So with that, each of those regions have a regional trial counsel and a regional defense counsel. So we thought it best to have a regional victims legal counsel in order that it would be in line with the fact that, again, this autonomous organization would have its own structure and be identified within each of the regions. They're all field-grade officers, and for those that are victims legal counsel, they administratively are assigned to those legal service support sections there in those major regions, but they are operationally under my control, and they report to me, and I evaluate on them. I think this allows the victim, as yesterday there was a comment about victims' rights in the manual for courts-martial, and victims have the right to be heard, they have the right to be present during hearings, and they also have the right to be known about pretrial negotiations. But I really think that this program is going to give them the voice that they always needed, because while those rules were in the manual, they did not really surface enough for them to be acknowledged and recognized. The Marine Corps, with regards to eligibility, the Marine Corps sees the Victims Legal Counsel organization primarily intended for active duty members and reservists on active duty that are victims of sexual assault. However, the Marine Corps is taking an approach that not only are we providing assistance to victims of sexual assault, we are also providing assistance through this organization for victims of other crimes. Also, we are looking at the eligibility of victims based on what's already in the statute that has given us the authority with regards to legal assistance, eligibility to all of those same individuals identified in 10 U.S. Code 1044, then emphasized in 10 U.S. Code 1565 Bravo. And that is that we will also include dependents, and the Marine Corps has decided not to distinguish its eligibility based on the age of these dependents. So the Marine Corps will look at victims not only of sexual assault, but all crimes, other crimes, as well as all individuals that are eligible within the statutory authority. The scope of representation is that these victims' legal counsel will provide confidential legal assistance to these eligible victims of crime in place of these legal assistance attorneys. And they will fully advise the victims of their rights in the military justice process, and actually, based on what my Army counterpart said, on all those matters, including explaining restricted and unrestricted, and all of the other options that they have. So I won't list all of those same things that Colonel McKee listed. But when these individuals are detailed, they will then represent them in a military justice proceeding in accordance with the statutes, regulations, and again, case law. If a victim has been involved in collateral misconduct, it's really imperative that we start with the victim legal counsel again. And let me explain, one thing is that we really felt that there was some confusion with regards to this collateral misconduct, that as soon as a victim identified some involvement with collateral misconduct, the mindset was to send them to the Defense Services Organization. Our Marine Corps message traffic last week, highlighting and announcing this program, clearly emphasized that any individual who claimed to be a victim that had any collateral misconduct mentioned would still see the victim's legal counsel, and only then will the victim's legal counsel decide and determine when appropriate to refer that individual to a defense services organization. That's the same with also traditional legal assistance, should there be those matters as well when discussing matters with the victim. We also emphasize the importance that's already drawn out in the statute, that again, it being 10 U.S. Code 1565 Bravo, allowing legal assistance to sexual assaults, to emphasize the importance of the SARCs, the victim advocates, victim witness liaison representatives, military criminal investigators and trial counsels that they must inform this victim of that there is a legal counsel available, and that they should allow this victim to consult with an attorney should they want to. This is a statutory requirement, and again, we emphasize it. We are not trying to take the place of all those services provided by the SAPRA, a family advocacy program, but only to augment it. For us, representation, duration of representation will be the duration of representation is considered basically complete when the convening authority takes action. That is that phase when the commanding officer has made his final decision with regards to the disposition of the case, and unless it's resolved sooner. But also that there may be exceptions, and those exceptions would have to be addressed by me or my boss, the Staff Judge Advocate to the Commandant of the Marine Corps. I'd like to take this opportunity that the Marine Corps officers and enlisted legal specialists have all been properly trained in preparation for this assignment. And I have to give some credit to both the Air Force and the Army for this. It was during the shutdown that we were scheduled to have this training, and while we were able to get the approval for travel, they definitely had the difficult task of ensuring that we got all the right people to give us this training and the experts that showed up for this. I can't tell you enough how important I think this training was with regards to the victimology aspect. And ensuring that people who take on this responsibility understand exactly what this job and this assignment will entail. So again, I thank my counterparts for that and ensuring that we were ready by 1 November, not only to have the individuals, but to have them specially trained in this case. With that, we have an operating case tracking system. We are keeping track in the last week of what we are getting in as consultation or contact with victims. Again, we're in the very early stages. I wouldn't say this is anything at all, and is something that will track the actual or measure the actual success of this program. I think that's a big challenge that we still have ahead of us. So in 1 November of last week, we've had all of our regions stood up, both with the Regional Victim Legal Counsel as well as some of the victims' legal counsel, and we will be providing on 1 January additional outline commands to be covered. So I thank you for this opportunity and look forward to your question.
Thank you, Colonel. We're now going to hear from Captain Fisher Anderson, who is Chief of Staff for the Victims Legal Counsel Program in the Navy. Captain.
Judge Jones and distinguished members of the panel, good morning.
Pull the mic closer to you, please.
How's that? Better? Okay. Judge Jones and distinguished members of the panel, good morning, and thank you for the opportunity to discuss the Navy Victims Legal Counsel Program. I'm very excited to be part of this tremendous effort to assist victims of sexual assault. By way of background, I am the Chief of Staff for the Navy Victims Legal Counsel Program. I am headquartered in Mayport, Florida, and my deputy, Commander Andy House, is headquartered in Washington, D.C. In my role as Chief of Staff, I'm responsible for leading, mentoring, training, and equipping 29 specially trained, independent judge advocates and 10 administrative support personnel. I report directly to Admiral James Crawford in his role as Commander, Naval Legal Service Command. Prior to assuming duties as Chief of Staff for the Victims Legal Counsel Program, I served as Chief of Staff for the Navy Defense Council. And before that, I was in command of Naval Legal Service Office Southeast. Prior to that, I was the Staff Judge Advocate to the Superintendent of the United States Naval Academy. In previous tours over the past 26 years, I've been assigned to both sides of the court-martial aisle. In my first 2 tours, where I was stationed overseas, first in Guam and then in Holyloch, Scotland, I performed duties as defense counsel. I defended sailors charged with sexual assault. And when I first joined the JAG Corps, both trial and defense counsel were assigned to the same command. So as a result, I had the opportunity to prosecute sailors charged with sexual assault. As I became more senior, I was assigned as the staff judge advocate and as a force judge advocate to 2- and 3-star line commanders. Military justice was always part of my portfolio, and as a result, I had many opportunities to advise commanders on sexual assault cases, both pre-trial and post-trial. I'm happy to report today that the Navy Victims Legal Counsel Program is off to a fantastic start. Our program is made up of 29 Victims Legal Counsel. 11 of our counsel are reservists, and the remaining 18 are active duty judge advocates. Every victim legal counsel was carefully vetted and professionally recommended for the program. Criteria for selection to be a victim legal counsel was based on the individual's desire to serve in that role, their experience level, professional maturity, and most importantly, their people skills. Our goal was to choose 3rd tour and junior 4th tour judge advocates with both trial and defense counsel experience. 20 out of 29 of our counsel met as a group for the first time during the week of 14 October in Montgomery, Alabama, where the Air Force provided some terrific training. We were exposed to experts on sexual assault that discussed victims' issues throughout all facets of the military justice process. A huge benefit of the course was the ability to roundtable with some of the Air Force Special Victims Council on best practices and issues that they had faced over the past 10 months of their practice. Admiral Dorenzi, our Judge Advocate General, flew to Montgomery and personally addressed the Navy and Marine Corps Council. Aside from her message, Admiral Dorenzi's appearance at the venue set the tone of the importance of the Victims Legal Counsel mission and her unequivocal support of the program. On November 1st, consistent with Secretary of Defense's direction, the Navy met initial operating capability. 21 of 29 Victims Legal Counsel have been trained and certified, and 9 of our counsel are in place delivering legal services. Locations where Victims Legal Counsel are currently assigned include the Naval Academy, Oceana, Mayport, Great Lakes, Coronado, San Diego, Bremerton, Pearl Harbor, and Guam. 6 additional Victims Legal Counsel will report for duty later this month and will provide services in Washington, D.C., Norfolk, Gulfport, Pensacola, Everett, and Rota, Spain. The decision on where to place our Victims Legal Counsel throughout the fleet was based on statistical averages generated from the Defense Sexual Assault Incident Database for the period covering FY12 through FY13. The Navy expects to meet full operational capability by January 2014. This includes completion of all remaining VLC training and certification and additional VLC presence in Groton, Jacksonville, San Diego, Lemoore, Ventura, and Bahrain. Additional deployment of VLC will continue until July of 2014. I'd like to just add by telling you that during my naval career, I have not seen a more enthusiastic group of attorneys ready and eager to go out and meet the mission. They're ready, they're prepared to assist, advise, and advocate as appropriate on behalf of victims of sexual assault. Once again, I'd like to thank you for the opportunity to speak on behalf of the Navy Victims Legal Counsel Program, and I look forward to your questions.
Thank you, Captain. I'd like to skip the seating order at least and now go to the Coast Guard. And this is Captain Tyler, Director of the Office of Special Victims Counsel, and then we'll hear from the Air Force last. Thank you.
Can you hear me? Good morning, Madam Chairperson and members of the distinguished panel. I have a short prepared statement and I'll answer questions afterwards. My name is Captain Sloan Tyler. I am the Coast Guard's Director of Special Victims Counsel Program. I have over 22 years of active and reserve service. I've been assigned as a staff judge advocate for more than 7 years and served as a base legal officer for the largest military installation in the Coast Guard in Kodiak, Alaska. I taught military justice at the Coast Guard Academy for several years and have been assigned in non-legal roles as the Border Security Officer in the Office of Law Enforcement and as the first Coast Guard Liaison Officer to the Royal Canadian Mounted Police. I have a number of years of experience working with my DoD counterparts in the realm of disaster response and DISCA. Today I'll present the Special Victim Counsel Program currently implemented by the Coast Guard. The Special Victims Counsel Program is a new program that was initiated in the summer of 2013 as part of the Commandant's strategic plan to address sexual assault prevention and response in the Coast Guard. The goal of the program is to provide appropriate legal support to victims of sexual assaults and to ensure the member understands their rights in the legal process and feels respected and included. And as one of the survivors put it, we'd like to provide a coherent, consistent, intelligent response. The Special Victims Counsel Program is initiated with a working group. They developed an initial concept of operations with operating procedures and policies that were modeled after the Air Force program. The concept of operations was also designed to support the Commandant's goal of improving the availability and quality of response support for sexual assault victims. Initially, we trained and employed a volunteer legal force. We are in the process of validating the initial operating procedures and finalizing the aspects of the program. Several new military and civilian positions have been authorized. The positions will include administrative support, junior and senior legal staff, and management staff positions. We intend to have a permanent staff, or some of the permanent staff, in place by this summer of 2014. I anticipate filling some of the legal billets in June. Exactly where the Special Victims Counsel Program will fit in within the entire Coast Guard legal program is still being deliberated. I'll briefly touch on the role. Special Victim Counsel are military attorneys who have received specialized training to provide support to sexual assault victims. Special Victims Counsels assist the member in negotiating the legal process, thereby reducing the anxiety associated with being a witness in the military justice system. We provide an additional resource to ensure the victim understands their rights and feels respected and included in the process. The assistance provided varies based on the needs of the member. In the initial phase, Special Victims Counsels are a source of information about the military justice process and facilitate victims' interactions with other professionals who are involved in the investigation, treatment, and prosecution. Some examples are counsel can provide assistance with obtaining victim support services and can engage and interact with the sexual assault response coordinator, with trial and defense counsel, and commands to help protect victim interests. Counsel can assist with obtaining alternative housing or work location for the member during the proceeding. Counsel can assist the member in obtaining therapeutic services, such as obtaining a companion dog or services related to that. The special victim's role may morph as our program matures. Currently, in appropriate circumstances, counsel may establish attorney-client relationships with sexual assault victims. Counsel may travel to the member's location when appropriate and be present with the member during military justice proceedings, interviews, and investigations, or other events to provide insight into the legal process and answer questions on the aspects of the military criminal justice system. Counsel may be authorized to represent victims in military justice proceedings. Coast Guard active duty and reserve members who are in an active or drilling status at the time of the offense are eligible, as well as family members who are eligible for the legal assistance program, pursuant to the statutes already cited. The process works in the Coast Guard. If a Coast Guard member reports that they are a victim of sexual assault, they are notified through the SARC that they are eligible for Special Victims Counsel. At that point in time, the sexual assault victim may notify the SARC that they would like counsel, and at that, all notification will go through the SARC to counsel. Counsel's contact information will go back to the SARC, which will then be provided to the victim so that the victim may initiate the contact with their counsel. We are treating the communications between a Special Victims Counsel and a victim as confidential and privileged, as described by Military Rule of Evidence 514. Since the program inception on July 15th, there have been 25 counsel detailed as Special Victims Counsel. We currently have 21 cases that are active. A case becomes inactive at this time when the victim no longer requires services. For example, when the military justice process is complete or all avenues of response have been exhausted. So far, Special Victims Counsels that we have 14 who are trained at this point in time have had 3 cases, at least 3 cases each. 2 have appeared at an Article 32, and 1 has appeared at a trial. And that's all I have. Thank you.
Thank you very much, Captain. Colonel Hankins, we'll hear from you.
Judge Jones, members of the panel, thank you so much for inviting us to testify today. First of all, I want to thank the survivors who testified earlier this morning. I think it's critically important, especially for those of us in uniform who are providing services to survivors of sexual assault, for us to hear their stories so that we can improve upon the responses that they had when they were sexually assaulted. So I really appreciate the opportunity to hear from them earlier today. I'm Colonel Dawn Hankins. I'm the Chief of the Air Force Special Victims Counsel Program. In that capacity, I lead a team of 24 Special Victims Counsel and 10 paralegals at 22 operating locations worldwide. So we're in CONUS, and as well as OCONUS in Germany, England, and in various places within the Pacific. Our mission is to provide victims of sexual assault with world-class representation. That's attorney-client privilege, legal representation throughout the investigation and prosecution processes. And I have had the privilege of running this program from its inception in January of this year. Just to give you a little bit of background about myself, prior to this assignment, I was the Chief of Justice and Courts Activities in our Military Justice Division. So in that capacity, I was involved in developing military justice policy for the Air Force. Prior to that assignment, I served as a staff judge advocate for a operational fighter wing in Holloman Air Force Base in New Mexico. And in all of my assignments as a judge advocate, in the 18 years that I've been in the Air Force, I have served as a trial counsel, defense counsel, and an advisor to a convening authority on numerous sexual assault cases. So that's the background that I bring to this program. To give you guys just a little bit of background as to why the Air Force decided to establish an SVC program on our own, in mid-2012 of last year, the chairman of the Joint Chiefs of Staff issued a strategic direction to the force that basically indicated, dissatisfaction with the progress that the services were making with regard to reducing sexual assault, and that gaps basically continued to remain in the full implementation of the SAPR program at all levels of command, from the highest level all the way down to the lowest. The Air Force Chief of Staff, General Mark Welsh, called upon all of us in the Air Force to do more, to protect one another from the crime, and to strengthen the support that we were giving to victims of sexual assault, and making a culture of respect and trust a reality for everyone in the Air Force. And he charged us with that basically in, I want to say, mid-November of last year, and that in turn led us to the development of the SVC program. The Judge Advocate General of the Air Force, Lieutenant General Richard Harding, proposed the creation of a Special Victims Counsel program in March, or basically in November of last year. So just a short year ago, although it seems maybe some days longer than that. The Air Force SVC program was implemented on the 28th of January of 2013, so we've been in business for about 10 months. And initially as a pilot program for the Department of Defense. And of course, as you know, this type of program, providing legal representation to victims of sexual assault, has been directed by the Secretary of Defense for all the services on the 14th of August of this year. Initially, we fielded our program with part-time Special Victims Counsel. We had 60 judge advocates serving part-time while still performing their other legal duties. One of the reasons we did it that way is because we wanted to immediately field the capability. And so in order to do that, we had to use folks that, essentially still had other jobs to do. In June of this year, we stood up a new division within our Air Force Legal Operations Agency that does provide an independent chain of command for the 24 Special Victims Counsel and paralegals that are assigned to my division. So I now lead that division. In the Air Force, our Victims Counsel services are provided by highly trained legal professionals, hand-selected by the Judge Advocate General. All SVCs must be certified as trial counsel, which means they have to have a certain level of military justice courtroom experience, trial experience, and they have to attend an SVC training course. And as mentioned before, we've actually hosted 3 now since we've gone into business. Our Special Victims Counsel teams, our JAG paralegal teams, they're organized basically into 10 regions worldwide, with each region covering about 4 to 12 different installations. We simply don't have enough judge advocates to assign an SVC to every installation that the Air Force has, because we have over 100 worldwide. And we truly believe that providing this service to victims of sexual assault will result in a more robust opportunity for victims to be heard, to take advantage of the rights that they already have as crime victims, and ultimately will enhance the military justice system as a whole. Since its inception in January, the Air Force's SVC program has assisted 555 victims of sexual assault, providing legal representation in 93 courts-martial and 92 Article 32 hearings. SVCs have participated in over 700 interviews with investigators, defense counsel, and trial counsel. SVCs have spent over 18,000 hours asserting victims' privacy rights in various portions of the process, ranging from protection of their mental health records from disclosure and admissibility of their prior sexual history at trial, to something seemingly minor yet so important to victims with regard to limiting seizures of their cell phones, personal journals, and diaries. SVCs are empowering victims by providing a voice in the justice process, helping them to submit victim impact statements. During the post-trial phase, we actually have a regulation in the Air Force that gives them the right to submit a post-trial statement during the clemency process. Enforcing their rights as a crime victim, whether it's their right to be present, the right to be consulted, the right to be notified, and various things of that nature. They've been addressing safety concerns that they have. I think that was an issue that came up yesterday, as to how do victims get notified that they could have a military protective order. They've been advocating for expedited transfers for our victims who want to be transferred, and I'm happy to talk about transfer of the accused and things of that nature that are going on later on. They've been helping them with collateral misconduct, and I think about the survivor that testified earlier today and the conversation that she had with the SARC, and I think to myself, boy, I really wish she had had an SVC, because that legal counsel really could have helped her with that situation. They've been addressing workplace and unit concerns, which you hear a lot about, this issue of ostracization, people in the unit taking sides, and really simply, at the end of the day, taking care of their needs. That's one of the things that we discussed at the training course, was doing a holistic legal intake, where really the whole point of the intake is to find out what does the client need and what can we do to help the client. Not surprisingly, many of our client concerns are similar to victims in the civilian sector. Protection of their privacy being probably, it's the number one thing. I think 82% of our clients have requested SVC support to protect privacy in some way. Respectful treatment, feeling alone and afraid, like they're the only ones out there and that there's no one there to support them. And really other civil legal matters that they might have. Like, for instance, if the sexual assault took place where they live, they have an apartment, and they want to be able to break their lease because they don't want to live in that situation anymore. So our SVCs are helping our clients with those things as well, which are very similar to concerns of civilian victims. Our clients also have issues and concerns that are unique to the military, such as this issue of collateral misconduct, because really that more so than any other job that you have, can really impact your career in a very devastating way if collateral misconduct isn't addressed appropriately. The integration of their private life with their work life and how a sexual assault can unravel essentially all aspects of your life. I think that really is a difference between, in some ways, the military life and civilian life, because you live and you work with the exact same people. It's all one community. Unit impact is also a huge thing, and the loss of control that our victims have that can really be compounded by military life and the fact that they're subjected to military orders. The other example given by the survivor was, I had to be at work at a certain time, and if I wasn't, then essentially I'm AWOL. So I think a lot of those things are very unique to our military victims, and those are the things that our SVCs are able to help our clients with. We knew we would be asked, is this program value added? Or are just more resources being thrown at yet another program with regard to the SAPR program, but yet there's no measurable results to be able to show for it? To answer those questions, we fielded a victim impact survey at the very beginning of our program, which we provide to our clients at the close of our representation. So we have 555 clients now, about 124 or so we've actually terminated. Terminated sounds such a bad word when you're talking military speak, where we've ended the attorney-client relationship, and that's at the point in time that we give them the survey. Some of the questions are objective in nature, and then some are very subjective. How did you feel about various parts of the process? We modeled some of our questions that we asked on an impact evaluation study that was conducted by RAND, who did this on various crime victims' rights clinics hosted by the National Crime Victims Law Institute, NCVLI. We asked questions such as, I felt I understood my rights as a crime victim. I felt I was able to exercise my rights as a crime victim during the military justice process. And questions such as, my rights as a crime victim were respected, and then we give them a chance to say, yes, no, and other options. And then we also ask about their satisfaction with the services of their SVC, which I do think is very important to find out. You can have a service, but how do you know if the service is any good or not? The feedback has, in my opinion, has been overwhelmingly positive that we've received. 92% indicate that they were extremely satisfied with the advice and support of their SVC provided during the Article 32 and court-martial. We did have one client submit a survey in the interest of full disclosure where she said she was dissatisfied with the advice of her SVC during the Article 32, and we found out the reason for that was the SVC couldn't be present. The legal office had scheduled the Article 32 hearing during a period of time where we were actually having our SVC training course, and it was mandatory for the SVC to be trained during that week. The SVC requested that the case get delayed, and ultimately that request was not honored. And the end result was, a victim who was not satisfied that she got the representation that she had wanted during that process. 98% would recommend that other victims of sexual assault get an SVC. 93% have indicated that their SVC advocated effectively on their behalf. And 96% indicated their SVC helped them understand the investigation and court-martial process, which is essentially one of the goals that we have of our program. Even more importantly than sort of the numbers of satisfaction, and I do think it was very interesting to me, we asked them about not only are you satisfied with your SVC, but are you satisfied with the trial counsel, with the investigator, with the SARC and the victim advocate? And overwhelmingly, the most positive satisfaction that they have of everybody involved in the process is their SVC. But to me, even more importantly, is the anecdotal feedback that they've provided to us. I'm constantly amazed that people even complete a survey. I, for one, don't like them, and I have to be forced to fill them out. But I'm the one who clicks the button to get through to the end. And I'm amazed that our clients not only click the buttons and fill out all this data, but then they also take the time to explain their answers and provide us with anecdotal feedback on how they feel about the process and how they feel about their SVC. And just to hit a couple of the highlights, I mean, I could give you hundreds, but I'll just give you a couple. My SVC made me feel comfortable and safe. I knew I had someone to help just me and no one else, someone to speak on my behalf. When you're a victim, you don't know who to trust. My SVC gave me that trust that I needed. At the time of the Article 32, an SVC had been appointed to me, and I was confident during the interview and not intimidated. The same thing goes for testifying as well. Since having an SVC, I felt much more a part of both the legal and investigative process. Not everyone fully understands the legal process. And in fact, I'm sure if you asked some civilian attorneys where we try to explain the military justice process, they go, huh? So I can only imagine what our young airmen who are 18 years old to 20 years old understand about the criminal justice system. But anyway, one quote was, "Not everyone fully understands the legal process, and not only is the emotional support important, the legal support is important too. I would have been lost without the help of my SVC during trial." And like I said, I have a lot of other great quotes that I could give to you. I think this is really important. This particular quote was really important to me too, because we started the program and we basically said, no matter where you are in the process, you're eligible and you can have an SVC. So we had some folks who got an SVC at the very beginning, when they first reported, and then we had other folks that had gone through the interview, the investigation, an Article 32, and now are at trial, and those folks received an SVC. And one of the comments from one of these clients was, after testifying at 2 other Article 32 hearings and 1 other court-martial, I can say wholeheartedly that my SVC made the utmost difference in making my final testimony an experience I could walk away from without feeling re-victimized again. Over 90% of our clients are female. We do represent about 10% of our clients are males. Over 80% are active duty, so that's essentially the main set of our client base. We do have some dependents of active duty members as well that make up the 10%, some reservists. And 90% of our clients that we represent had filed an unrestricted report. So these are people that are actually going through the investigation and court-martial process. For those 10% that are have a restricted report, they basically represent 59. We have 59 clients that had filed a restricted report and had asked for an SVC. So of those 59 clients, almost 50% have converted from restricted to unrestricted after consulting with an SVC. And I think the reason for that is a lot of them were interested already in the idea of conversion, but they just didn't know, and they really wanted to talk to an attorney in a confidential setting where their name would still be anonymous, where they could really find out, no kidding, what am I going to get myself into if I decide to go unrestricted? And to me, I think this is a huge benefit of the program, is being able to reach out to those folks who really have a lot of questions, and that they can talk to an attorney who can explain to them exactly what an investigation is going to look like and exactly what a prosecution process is going to look like. Now, we do have some of our restricted clients, it's only for 50% conversion rate. So we do have some of our clients who have elected to remain restricted. They don't want to convert. They don't want to file an unrestricted report. And I know this was a question that was being asked yesterday. Why do people not want to report? Why do they not want to file an unrestricted report? What I can tell you from our clients is, of those who have not converted, what we do know is that everyone's reason is personal. And so there is no one-size-fits-all response as to why people don't report or do report. It's all very, very personal to them. But I can kind of tell you overall, the reason that they don't report falls under the umbrella of privacy. They don't want others to know the details about their personal life. Some have concerns over collateral misconduct that they were involved in, and they simply do not want their family members to know that they might have done some other things. They don't want to be treated differently once they come forward and report, so it's that social stigma that comes from being the victim, a rape victim or a victim of sexual assault. For some, they don't want to report because they just don't want to be a burden onto others for various reasons. I think some of it has to do with self-blame. You know, they think I should have done something differently. If only I had not had so many drinks. If only I had left the party with my friend when she left or he left. And for some, I think it's the process, the criminal justice process, not just the military justice process, to be clear on this. The criminal justice process is just so hard and so difficult for victims of sexual assault. And some of them simply just aren't willing to go through that process. They just don't want to do it. Particularly when they're afraid that at the end of the day, there's not enough evidence to convict the offender. And so why do I want to put myself through that? So those are the reasons that I can tell you about our clients who have decided not to convert to an unrestricted report. Well, I could speak for hours on this subject, but to conclude and save time for questions, I just want to highlight that I think the initial success of our program really has to do with the 110% dedication that our SVCs and paralegals have brought to this new program and have really broken new ground within the military. To think that we never even had this practice area a year ago, and here they are doing just phenomenal work for their clients that is being seen in increasing their satisfaction with the process. And I think any time that we can do that, then that's a good thing. And I'm really so incredibly proud of the people that I am so privileged to lead in this endeavor. I think also important to our success has been this continuing outreach that we've done with other outside organizations, to include NCVLI that I mentioned before, who's been extremely helpful to us, the Victims' Rights Law Center, and the Office of Victims of Crime through the Department of Justice. We've really teamed with all of them. And I think that robust partnership and extensive policy development and commitment really at the headquarters level. We've had 110% commitment, not only from the leaders within the JAG Corps, but also our commanders within the Air Force. And so I really appreciate the opportunity to come here today and answer your questions. Thank you.
Thank you, Colonel Hankins. Admiral Hauk?
Good morning. So resources. There was testimony yesterday from one of the witnesses, Admiral Buck from the Navy, who spoke with some striking candor about the fact that resources have been moved quickly to this project in the Navy, and that there are now things that aren't being done in the Navy because of this. And what I'm interested in is, from each of you, your sense of the permanency of the program. And I realize to some extent these questions may be considered, above your pay grade, but you're here. So what I want to know is your sense of the commitment of the services to this, number one, and number two, to what extent you think this is going to pressurize the rest of your community in terms of providing legal services elsewhere. Back to Admiral Buck's point, the things that aren't being done because of the relatively quick movement of resources to these programs. I don't want to call on anybody in particular, but anybody want to speak to that?
Yes, sir, I could address that first for the Marine Corps. With regard to resources, first of all, when the Marine Corps decided to set up the Victims Legal Counsel Organization, we decided that we wanted to start out by going into the active duty side. It was really important to force the structure into the judge advocate community structure and not start with the reserve side of the house, because we needed to also force the request for additional judge advocates from our higher headquarters. And so we had to go in, though, with the assumptions that we would not affect, by way of doing this, those complex cases that were already being tried, and ensuring that we didn't diminish the capability with regards to cases from the trial and defense side of the house. So it was really difficult because in the Marine Corps we're very small. Our judge advocate community is very small, but the SJA to the Commandant of the Marine Corps has a request in and has been approved for additional manning into the judge advocate community, even when we have to cut a manning across the board in the military. So that's one of our first.
If I could interrupt, because I think that's really what I was getting at. Do the rest of you have specific insight as to if there's going to be additional resources to cover this important mission? And the backfilling that's required behind it?
Yes, sir. In the Air Force, we initially took this capability out of Hyde, out of the JA Hyde, which meant that these 24 SVCs were formerly in installation-level legal offices doing work for a wing commander, that were now doing our work. We were fortunate enough that the Air Force Council actually provided us with some manpower billets to be able to go back to the field, but it wasn't a one-for-one backfill for those folks that are gone. But I can see that I don't think we're at the end state yet. We don't know exactly how many judge advocates we're going to need. To me, I think it's going to be based on the caseload. We don't even have a year's worth of data yet to know, are we going to have a 600 person caseload every year sustainable or not? And so I think that there's a willingness, at least within the Air Force, to be able to continuously look at this and be able to go back to our Air Force corporate structure to ask for additional resources. During that interface, basically, I think some services were limited, and mainly in the legal assistance area. And so longer wait times to get an appointment to be seen if you needed a will or other types of civil law legal matters is really where we sort of cut the line on what services would we either reduce or maybe just not have as available as they had been in the past.
Sir, for the Army, General Darpino, our TJAG, feels this program is so important that she also addressed all of the SVCs at the course in October. When she briefed the chairman, the Joint Chiefs, the chairman of the Army, he authorized 20 reserve component judge advocates to be put on active duty to backfill legal services as we pulled active duty judge advocates from the legal assistance office to perform these services.
That sounds pretty temporary, though.
What we're doing right now, sir, is we're conducting a year-long manpower study, and every SVC and every legal office has a manpower sheet where they're going to document the time, the minutes, and the hours that they spent on these services. After that year, we're going to come back and we're going to go back to the Army and we're going to say, based on these number of hours that we've performed services for these for victims, for clients, we need X amount of attorneys to fulfill this requirement. This program is here to stay, and we're planning on it staying, and after 1 year, we're going to go back to the Army and say we need X amount of attorneys to provide the service.
Okay. Thank you.
Sir.
Madam Chair, I have a question as well.
I want to allow them to, yeah.
Sir, from my perspective, and I'll be happy to take this back for the record, I'm unaware of any legal missions not currently being met. Attorneys are doing more with less, I will say that. Their portfolios may be a little more varied than it used to be. But the Navy has proposed increasing the JAG Corps end strength through the DoD budget process by 30 billets. That's the 30 billets that we have already brought online for the Victims Legal Counsel program. When the program was initially mandated to be stood up, Chief of Naval Operations said, we will help get 30 more billets to the JAG Corps. Initially, though, because we had to meet an aggressive implementation guideline for the program, we reached back to our reserve force. And as I said during my opening remarks, 18 of our 30, or 29 VLC, I count as one of them as the Chief of Staff, but the 29, 11 of them are reservists who have come on board and will remain with us, some for only a year, and then we had recently a recall board where we could have up to 3 of those reservists remain with us for 3 years.
And has the Coast Guard made a commitment to fill this mission?
Yes, sir, and the Coast Guard has already had billets created and approved. So the Commandant of the Coast Guard is committed to eradicating sexual assault in the Coast Guard, and committed to this program.
So you're all saying that each of your services has made a commitment to you in one way or the other to provide, at least at the part of, after some analysis is done, in some cases, to providing additional resources to fill this mission.
Yes, sir.
Yes, sir.
Thanks.
Thank you, Madam Chair. The question I have, and is to either any of you, is who on behalf of the victim helps them navigate through all of the legal process piece, but then there's also the counseling services piece, you've got the personal and professional guidance piece, the linkages between all of these different services that we're hearing about, and now this new service, it can be overwhelming for a victim. Who do I go to, and who takes the lead in navigating this so somebody doesn't fall through the crack?
I can take a shot at that one. What we found is that a lot of it has to do with who the victim client, in our case, is the most comfortable with. And so if they're the most comfortable with their victim advocate, then the victim advocate might be the one that sort of guides them through various parts of the process. But I think in our experience, what we've found is, for the most part, it's been the SVC. So they've come to the SVC, and the SVC is that sort of that central person that they use to be able to access all these other services. And so I think it's one of these things that we have to bear in mind, that this is a team approach to providing services, and that really we see the role of our SVC to be in there to kind of, you have all these services available, and it's the SVC that's filling the gap amongst all those services and making sure that they are getting all the services that they want and need, whether it's medical care, mental health services, issues with education, training problems, et cetera. So at least in our experience, we've seen that there's a comfort level with their attorney that they have, that they do tend to turn to them to help them access services. Our SVCs aren't providing them with counseling per se, but they are the ones that, to be able to call the victim advocate, or maybe to call the SARC, or even to call directly to the provider to say, we need to get this person some services.
I'll say the Coast Guard's been doing this for 4 months, so we don't have a long time, but we view this as a collaborative effort. Really, it does depend on what the victim, survivor, member desires. We do quite a lot of communication with the SARC and quite a lot of working with the SARC to ensure that, one, the victim has been provided the information that they can get counsel if they want. So once that determination has been made, and once that victim wants special victims counsel, we tend to work as a team to try to address all of the needs of the individual. And for the 25 cases that we've had, most of the issues are very unique to the member. I haven't seen a lot of consistency. We haven't had a lot of cases yet, but I haven't seen a lot of consistency with respect to what each member desires. They have individual needs based on the facts and circumstances, and those are up to the Special Victims Council to make sure that they use their skills to advocate on behalf of the client to get what they need.
Madam Chair,
Professor?
this is a tremendous ray of hope. I want to thank you for your work on this, and this is not a topic that always inspires a lot of confidence in the way we're addressing it, and your commitment to this and the freshness of this approach is actually very compelling, so I'm grateful for that. I have two specific questions for you, and it's based in part on reading the Secretary of Defense's letter that set this out, and also the Title 10 provision that Colonel Joyce specifically referred to, that 1565B piece. The first is about duration, and in part this is inspired by the victim's testimony earlier today about the difficulty of continuity with respect to services provided through a transition out of the military, if that's in fact what happens after an incident like this. And the SecDef's directive said it needs to be legal assistance throughout the justice process. And Colonel Joyce, I think you said that it terminates at the convening authority's action. Colonel Hankins, I'm not sure when it terminates in the Air Force, which has the greatest experience with this, so you could share that too. But I wonder what you think that means right now throughout the justice process, and if you've thought about how to make that handoff. This would be a client losing representation based on a policy we're setting out that is counter to, that is unusual in our experience with attorney-client relationships. And then my second question is about the military or civilian piece in terms of who this person ought to be who provides legal assistance, because the Title 10 specifies military or civilian legal assistance. And to what extent, I wonder, as you were standing up these programs, you've articulated the reasons for having military counsel here, but given the resource considerations that Admiral Howe pointed to, and you all are working hard, I'm sure, to make sure you're staffed appropriately, I wonder how much you considered the use of civilian advocates in this process.
Sure, I'll take that too. Generally speaking, the duration of our attorney-client relationship is from the time that they come in and they decide they want to be represented, then we have them sign a representation agreement that kind of outlines the scope of representation that we have. And our rule is, generally, representation will terminate when case disposition is complete. So whether that's the decision that the case is not going to trial, or it's the decision that we're going to trial, we get them through the trial process, convening authorities take an action. At that point in time, we have our SVCs talk to the clients to find out, do they have continuing legal needs? Do they have continuing concerns? Because if they do, then that relationship continues. So we actually have them officially terminate the relationship by signing a document. Just like if any other representation that you have with a lawyer, once your legal services are done, then your representation's complete. So I don't think it's a one-size-fits-all. And we've certainly trained our SVCs, please, whatever you do not, the day after the acquittal say, hey, we're done, right? That's not a good way to approach your client. Not to say that any of our SVCs would do that. They're very sensitive. But I think it's definitely a discussion that is had with the client on what needs do you have? Are there things that I can still help you with? What are your concerns? And generally, we find that our representation actually terminates, months after the final disposition is over, that it is a discussion, an ongoing discussion that is had over several weeks, just to make sure that that client is okay and is in a good place. And at that point in time, I think really where we decide, okay, we don't, I'm not going to continue to have a legal obligation, an ethical obligation to you, to ensure that they still have the services of their victim advocate or whoever it was that they chose to utilize. Some may not have a victim advocate by their choice, or maybe they were really comfortable with a SARC. Then we just make sure that there's someone still there to be able to take care of their needs. And the last thing that we tell them is, hey, if you ever have another problem or another need or another concern, just because I'm no longer your lawyer right now doesn't mean that you can't come back in and you can come in and see me. So just because the official representation is over for that particular incident, if something else happens or they have some other legal concern, then they can come back in just like they could today and go in and see a legal assistance attorney to address their needs. So that's how we've dealt with that.
Over the short run, that seems reassuring, but over the medium and long run, it's less reassuring to me. In that, I think an analogy to think about here are wounded warriors, and the progress that the services have made in understanding and realizing that the complexity of these issues last a long time, and you clearly understand that, but we are not going to be in a situation where budget pressures don't exist. And as resource pressures increase, continue to be severe, this is the kind of thing that is left to policy that in terms of the scope of representation and the length of representation, it can get watered down and it can get diluted that way. So everything you say is reassuring, but leaving this to informal mechanisms and policy is a little bit less so.
Well, sorry, I just have to also point out, our attorneys will go on to do other jobs in the Air Force. They will not be victims counsel forever. And so they do have to be able to have the freedom to be able to go and deploy for a year if that's what the Air Force needs for them to do. Or maybe they actually move into a different job, such as a defense counsel job. And in those circumstances, it can be very difficult for them to still have ethical, legal responsibilities to someone in a job where they can't fulfill that because of the job demands that they have.
I don't think, though, that survivors are going to be impressed by the needs of the Air Force to transfer people. So I think the services are going to have to come to grips, and to some extent with the way Professor Hillman is talking about, with integrating civilian counsel into this process for some continuity.
Just to add on the Air Force's testimony in terms of, at our course, we told our Special Victims Counsel how to advocate on behalf of the client in the parole system. So we do envision their advocacy going beyond action, so that the victim can get matters before the parole board for someone who's been convicted of this crime. So we envision it going a little farther.
Madam Chair.
Thank you. Thank you all for being here, because this is new, and for even those of us who have military experience, it will be something we've never experienced. So getting the benefit of what the Air Force has done for the last 10 months and listening to what the other services are planning is incredibly helpful. And the comparison of all of you sitting side by side is interesting. And where my questions, the first couple of questions I'm going to ask, they're going to be short questions. Do I understand that for the Air Force, I think the Marine Corps, you said it's for all offenses. This isn't just sexual assault offenses, that this Special Victim Counsel will be available. Is that true? All of you?
For the Marine Corps, it is victims of sexual assault and other crimes.
How about the other services? Is it other crimes as well?
No, ma'am.
No?
For us, it is sexual assault.
How about Air Force?
Yeah, limited to sexual assault victims at this point in time. I think that's an issue that we're willing to look at in the future, but we wanted to make sure we fielded this capability first.
An Army?
For Army legal assistance for other crimes and for victims of sexual assault, they SVCs.
Okay, and in the Army, it's where I have a small concern. In the Air Force and the Marine Corps, you both said you set up separate organizations to do this. You have separate rating commands. In the Air Force, the Special Victim Counsel, if I understood you correctly, if there is collateral misconduct, rather than referring them even to TDS at any point, that Special Victim Counsel becomes the Victim's Counsel. They help them through all of it. There is no referral. In the Marine Corps, I think, Colonel Joyce, what you said was it's up to the victim. They'll see the Special Victim Counsel. They've got somebody they can speak to, and if there is misconduct, then it'll be the Special Victim Counsel that gets that to TDS.
Yep, that's right.
Okay.
Just to clarify for the Air Force, our SVCs can represent them for collateral misconduct. And if it's significant enough, then we would refer them to an area defense counsel who is very experienced in representing someone, say, for example, if they turn out to be the accused in a court-martial case. But our SVC could actually stay on the case, so they would represent them jointly.
All right, and Colonel McKee, and I may just not have misunderstood. I think I heard you say it's legal assistance counsel. One of the qualifications is whether they've got what their military justice experience is. Please inform me, are you using only judge advocates even in the Army?
Yes.
Okay, because my experience has been, usually legal assistance attorneys may be one of their first jobs. They usually don't have a lot of justice experience, although some of our civilian legal assistance attorneys are former military, they might. So I know the statute allows both. But if it goes to a legal assistance attorney, I think you said if there's collateral misconduct, that'll get referred to TDS. Do you envision at some point then a victim could have two counsel, the Special Victim Counsel, a TDS attorney, and then who resolves those conflicts?
Yes, ma'am. In terms of, for collateral misconduct, that does not bar the SVC from still seeing that, from representing that client through the system. It's going to have to be we're in discussions with Trial Defense Service in terms of trying to work out a memorandum of understanding as to how that's all going to work out. So we still need to do some work in terms of that, whether the trial defense attorney will take it if it's collateral misconduct in terms of the seriousness of it. But the client is entitled to a Special Victims Counsel no matter what, collateral misconduct or not.
Right, but I'm sitting here thinking of since I didn't know anything about the program, so hearing the Air Force and what you've done was really helpful. But even when you were saying that you've had a couple of cases where that one person has been asked at the request of the judge to appear at the Article 32, present evidence on a rape shield type of motion, 412. I have this image, even if they're going to just an interview, at what point does an SVC start advising, if they refer collateral misconduct someplace else, and the SVC is sitting there, and they want to advise them to I advise you to keep your right to remain silent from an SVC, or do they not advise that because that's the TDS role? And I'm wondering where that line is. I'm also interested in knowing, I heard how you said the Army in the 3 cases. How far have special victim counsels gone in their presentation or advocating the victim's views in a court-martial in the Air Force so far? I mean, on a motion, it's one thing, and I think you said, Colonel McKee, you had given us 3 cases recently. I thought one was they appeared in an Article 32, and for 2 of them, they presented post-trial matters.
It was all one case, ma'am.
All one case?
Yes, ma'am.
How about the Air Force? How far does that? I mean, that conflict is something that you may not be able to answer it. It may be something that's out there. I will tell you, sitting here, that's a concern that I have, just the way it's structured. Or the rating chain. If you have a mirror organization to trial defense and your victim counsel all rated separately, except maybe the Navy, in the Army, they're not. They're rated through the legal assistance. And what if they do have to come forward and voice something contrary to the command? Has that been considered?
Yes, ma'am, it has been considered. I am their technical supervisor, so if there is a conflict or there's some kind of adverse relationship, they come directly to me, and I will raise that issue with the SJA and bring that to the forefront. But our TJAG has considered that, and she believes that using the legal assistance model is the correct model, and they do have direct access to me. I talk to the SVCs every day. They email me every day. We talk about professional responsibility issues every day. We talk about these conflicts that they may have. So that is being done, and our TJAG does understand, the difference between. She does understand the pros and cons of having a stovepipe organization and the pros and cons of having it in the legal assistance office.
Including the military justice background, if they're a direct commission and that's a first assignment. But then that might not be the person you choose.
Yes, and the SJA has directed in her TJAG sends that SVCs should have military justice experience, either trial defense or trial counsel, and they must be mature and have sound judgment.
And for my fellow panel members, a TJAG sends within the Army when the Judge Advocate General wants to send a message to the field on a new initiative or something of importance. They'll usually write a 1-page statement that'll go out to all Judge Advocates and tell them, hey, look, this is what we're doing, this is why we're doing it, and here's my guidance on it initially. And it's a companion or a complement to whatever the policy is. Okay.
Ma'am, just for clarification, VLC with the Navy is an independent chain of command. I will be the reporting senior, and our Victims Legal Counsel will handle collateral misconduct that has a direct nexus to the report of sexual assault.
Madam Chair?
Yeah, Ms. Saltzman?
Thank you very much, Madam Chair. Thanks to all the panel members for coming and sharing this really important experience with us. I personally am very grateful. Colonel Hankins, I think you looked at me when you mentioned the issue of satisfaction of the victim.
I might have heard you ask that question a couple times.
And so I really appreciate what you've done about that, and I wanted to ask the other services whether they have included victim satisfaction surveys based on the model of the Air Force, or based on any model.
Yes, ma'am. Actually, we've modeled our survey after the Air Force's. So, yes, we are doing that also.
We are in the process of modeling ours. Yes, ma'am.
And the same here, ma'am.
We don't have a survey that I'm aware of right now, but it would be great to get that feedback, so we'll look into that as well.
Excellent. The second question I have is with regard to the Marines. If the Special Victims Advocate service ends at the time that the matter is referred for court-martial, how can that Special Victim Advocate help the victim with regard, for example, to the victim impact statement?
Well, I just want to clarify that when I said that.
Maybe I'm not understanding the testimony.
Right, the intent is that we were looking at with regards to policy, where do we at least try to draw some line here? And I think Colonel Hankins said it well, is that because of the transfer, reassignment of military members, so we definitely knew that we would look at the convening authority's action, the completion of the convening authority's action as a possible area. I mean, our focus with victims is twofold. One, we want to empower them with the ability to have an attorney. And secondly, we want to continue to ensure we give them confidence in the military justice system. So we are not saying really that it's the fine line. It'll be case by case, and that's why I prefaced it with that, at those exceptions or those cases that have to go beyond CA's action would be evaluated by myself as the OIC or my boss, the staff judge advocate to the Commandant, because we do have the appellate review process, which could be very significant. Right now, our manual does not address a victim's rights with regards to the appellate review process per se, kind of like what I had addressed with being heard at a court, in a court-martial for, the motions hearing with regards to the Rape Shield Act, or being heard or being able to be present in the proceeding. So these are things that we need to see changed also so that we can ensure that we can exercise those types of rights. But right now with the appellate review process and the boards that follow involving the accused, we clearly would like to have it. And if it requires a change of counsel, we want to make sure it's a warm handoff and ensure that we can keep that confidence in that victim.
Great. This question really arises from the testimony this morning where one of the witnesses mentioned that she had gone to the SARC and the issue of having to stay in the unit, and also that the issue of collateral misconduct. I'm trying to understand, and my opinion was that that advice was problematic. Let me just be diplomatic about it. Where in the new system does the special victims advocate get inserted so that if misinformation is given or improper information is given, that's not an ending of the process, that the victim will be able to get the benefit of alternative advice from the get-go, so that...
Yes, ma'am, I'd like to take that one. Well, first of all, that should never happen today, because there is a regulation in place that says if someone comes in and reports a sexual assault, you must refer that to the criminal investigative agency. So my understanding was that happened in 2006. Whether or not that person was a full-time SARC who's gone through all the training that we've had since then, I don't know. But I would like to think that today, in 2013, that scenario would never happen. And if the SARC did say something like that today and did not refer the member to a criminal investigator, then that SARC should be disciplined. And I would expect that to happen, number one. Secondly, how an SVC gets interjected into the process. The SARC, the first person who comes in contact with a victim of a sexual assault, someone who reports a sexual assault, whether it be a SARC, a victim advocate, commander, law enforcement, trial counsel, legal office, whoever, the first responder team, they are required to notify the victim that they are eligible to have a victim's counsel appointed to them. And if the victim says, yes, I would like to have an SVC, then they make that referral over to us. So that's one way they get interjected into the process. The second way that they can do it is simply to call us directly. We have gone on a media blitz over the last several months where we've put posters up at every installation and the bulletin board of every unit that says, this is the SVC for this installation, and you can call me directly, and it has their phone number. So we have, for the most part, we get referrals. They go in and report to the SARC, and then the SARC brings them over for the appointment. But we do have a very small number of our clients who've actually called us directly, and we really were the first person that they contacted and called directly. So there are multiple ways to actually get the SVC involved in the process.
Thank you, Colonel. Do the other systems services, does it work the same way?
Typically, we've been seeing them coming through the SARC, but It works the same way in the Coast Guard. They can call directly.
Right, but at the minute that this is reported, or to the very first person, the very first time that it's reported, that first receiver of that information in the Coast Guard is required to alert the victim.
Provide them notice that they are entitled to call a Special
Right.
Victims Counsel. Yes,
Is
ma'am.
that true also for the Marines?
Well, that's definitely true because it's a statutory requirement, and it's in 1565 Bravo, that they must inform a victim that comes in through the SARC, the victim advocate, the victim witness liaison, the military criminal investigator, and trial counsel must inform the victim that they can have an attorney, and now we would be referring to it as a victim legal counsel.
That's the same for us, ma'am.
Okay, great. Now, also derived from today's testimony, what happens to somebody who's left the military and hasn't reported and never received the services? Would they be eligible for yours if they say, for example, I'm not talking about this person, but hypothetically, someone who left the service a year ago and had been the victim of rape and never reported it? What would happen?
Ma'am, the authority to provide the service under the legal assistance rubric is based on 10 U.S.C. 1044. And so the person has to have some sort of status in order to be eligible for legal assistance. And in those circumstances, the person is just separated, they're not a retiree, for instance, then they're not eligible for any legal assistance by any military, judge advocate or civilian attorney. So there's simply no way for us to be able to provide this service to them legally. We have no legal authority to do that. So in those circumstances, if I were to get notified that a separated member of the services wanted to have a victims counsel, well, we have all these wonderful, fantastic civilian resources available, and I would try to refer them to a pro bono attorney through the NCVLI clinics, from the Victims' Rights Law Center. We have such a great network that we've established. And in fact, I've had a couple of people that haven't met the eligibility criteria for our program, but really kind of needed the help of an attorney, and they've really stepped in and helped out those clients that we weren't able to help.
Thank you very much.
Just one question. Would it be easier for you to litigate for victims' rights if the rights were embedded in the UCMJ?
I'm a strong proponent of clarifying that whether or not the Crime Victims' Rights Act, the CVRA, explicitly applies to the military or not, because I think that is an issue that is unclear. The military appellate courts have not made there's been no final ruling on that. And while we have incorporated many of the rights by regulation, I think all but two are actually incorporated by regulation, there's still the two rights don't apply, or arguably don't apply, and there's no enforcement mechanism to enforce those rights. So if there is a violation, then how do we go to the courts system to enforce the violation of those rights? So I do think that that is a gap that still remains as to whether or not the CVRA explicitly applies to the military and how it should apply to the military.
The only thing I'd like to say, I guess, here at the end is, this is a program, even though it's only been going for a year in the Air Force and now it's service-wide, that has the likelihood of being a tremendously popular program among victims. It sounds like it is empowering the victims who've had these services and will continue to do that, and it's also strengthening their confidence in the system, which are extremely important purposes, obviously. But I echo the concerns of Admiral Houck and others that the resources are going to have to keep coming, because if you are a success, you're going to have a much larger caseload. And I really also have concerns about continuity and wonder if you might all think about a civilian cadre to handle this particular service. It would be a tragedy if a terrific program were developed and then it couldn't be carried through on. Thanks very much. every one of you, and it's been wonderful to hear from you. Terrific program, and I admire all of the effort